When you hear the phrase forensic medicine, what is the very first image that pops into your head?
I mean, if you watch any television at all, it's definitely a dimly lit room.
Right, a stainless steel table and a solitary, brooding pathologist.
Exactly. They pull back a sheet, stare at a body, have this sudden flash of genius, and just single-handedly unravel the final moments of someone's life.
We have all seen it 1,000 times. The lone doctor who somehow, does the autopsy, tests the DNA, confronts the suspect in an alleyway, and then brilliantly argues the case in front of a stunned jury.
It's the classic cinematic autopsy scene.
But what if I told you that is not just a fraction of the story, but a fundamental misrepresentation of the entire discipline?
It really is.
What if the true heart of forensic medicine doesn't actually beat in the mortuary, but rather it begins the exact moment you step out of your clinic and into the stark, fluorescent reality of the legal system?
That is a profound shift in perspective. And frankly, it's the only safe place to start if you were actually practicing medicine.
Because that popular media representation, while it's compelling entertainment, it does a massive disservice to the reality of the profession,
A
right?
huge disservice. Forensic medicine is absolutely not solely about the dead. If you look at modern forensic practice, an overwhelming majority of the work is dedicated entirely to the living.
We are talking about clinical forensic physicians evaluating victims of assault, pediatricians safeguarding vulnerable children.
Psychiatrists assessing mental capacity.
Yeah, and doctors dealing with insurance medicine, refugee healthcare, custodial medicine, and incredibly complex civil proceedings.
It is this massive, intricate intersection where medical science, clinical ethics, and the rigid rule of law all just collide.
And that collision is exactly what we're going to explore today. We are doing a deep dive into the foundational legal and ethical architecture of forensic practice.
This is specifically tailored for medical students staring down their exams, junior doctors trying to figure out their legal responsibilities,
And senior clinicians who might suddenly find a witness summons sitting on their desk.
which happens more often than you'd think.
Exactly. To do this properly, we aren't just pulling ideas out of thin air. We are using the structural spine of Chapter 1 from Simpson's Forensic Medicine.
So, if you are studying or revising right now, keep your textbook open.
We are going to translate those pages from abstract legal concepts into actual, clinical survival skills. We want to build a conceptual framework where you understand not just what the law is, but how it dictates every single word you write in a patient's chart.
The mission here is to understand the legal ecosystem you are operating within. The central overarching theme you will find at the very beginning of the text is quite philosophical, but it has gritty, real-world implications.
Which is that the rule of law exists to prevent anarchy.
Exactly. It is a framework established over centuries for the mutual benefit of the population to ensure disputes are settled by evidence and reason rather than violence and chaos.
And forensic medicine exists to serve that exact framework.
But it can only serve that framework through unshakable objectivity, strict proportionality, and fierce independence.
I want to pull on that thread about anarchy for a second because it feels almost melodramatic for a medical textbook to start there.
It does sound a bit intense.
But when you think about it, it makes perfect sense. The law is just a set of rules governing orderly behavior. If medical evidence in a courtroom is biased or sloppy or fraudulent, you get innocent people going to prison and dangerous people walking free.
That is a form of localized anarchy.
Right. And what I found really striking in the reading is how heavily it emphasizes the multi-professional nature of this work to prevent that exact chaos. It explicitly states that each practitioner provides only a small piece of the jigsaw.
Which brings us right back to why that TV trope of the lone genius is so dangerous.
Nobody does it all themselves.
In reality, solving a crime or resolving a complex legal dispute is the result of meticulous, painstaking, and often, frankly, tedious effort by a large, multi-professional team.
You might be the emergency physician who simply notes the exact dimensions of a laceration on a Friday night.
Someone else is the scientist analyzing a single blood drop. Another person is the forensic photographer.
You are holding one jigsaw puzzle piece. You do not get to see the picture on the front of the box.
And crucially, you do not get to put the puzzle together yourself.
That requires a massive amount of jurisdictional and professional humility.
It really does.
I mean, if I'm an emergency room doctor and I see a spiral fracture in a toddler, every instinct in my body might scream abuse.
Naturally.
But my piece of the jigsaw is documenting the fracture, stabilizing the patient, and triggering the safeguarding protocol. I am not the judge, I am not the jury, and I am not the detective.
The final arbiter of how all that evidence is interpreted in the context of the whole case is always the court.
Always the court.
Precisely. The moment you try to build the whole puzzle yourself, you step outside your professional boundaries, and that is where miscarriages of justice occur.
And speaking of boundaries, it is vital to understand the dual layer of accountability that healthcare professionals face. You aren't just bound by the general laws of the land like everyone else.
Right. There is a whole secondary rule book.
If I get caught speeding on the motorway, I deal with the police and the courts, just like my neighbor who works in accounting. But as a clinician, the consequences don't stop there.
They do not. Anyone working in medical, healthcare, or scientific professions is bound by the same criminal and civil laws as the general public. But layered entirely on top of that are professional regulations, standards, and codes of conduct specific to your discipline.
Like the General Medical Council.
Yes, a regulatory body like the GMC in the UK or the Medical Board of Australia has the immense power to sanction you for inappropriate professional behavior, even if you haven't technically broken any national criminal law.
So I could theoretically walk out of a criminal court with a complete acquittal, totally clear of any legal wrongdoing by a jury.
Yes.
And the medical board could still say, actually, looking at your conduct, you failed to meet our professional standards, and we are revoking your license to practice.
Absolutely. The legal bar for staying out of prison is completely different from the professional bar for keeping your stethoscope.
It's a completely different threshold.
And a major focus of these regulatory bodies today is policing, how doctors behave when they interact with the legal system. This brings up the highly toxic concept of the hired gun.
Yeah, that phrase sounds incredibly sinister. It sounds like an assassin. But in the medical context, it's almost worse because it wears a white coat.
A hired gun refers to a fraudulent professional who essentially sells their opinion to the highest bidder in a legal case.
They just tailor their medical or scientific testimony to suit the narrative of the lawyers paying their invoice rather than remaining objective.
It is a fundamental betrayal of the scientific method. This behavior risks undermining the credibility of the entire medical profession in the eyes of the public.
And the real-world fallout is devastating. You have doctors who get so caught up in the adversarial nature of the court, or they get addicted to the hefty expert witness fees, that they start shading the truth.
They emphasize findings that help their side and conveniently forget to mention findings that hurt it.
Which directly causes those miscarriages of justice we mentioned earlier.
This is exactly why, for instance, in the United Kingdom, the government established the Independent Forensic Science Regulator.
This isn't just a casual advisory board.
Not at all. This is a body specifically tasked with establishing and rigorously enforcing strict quality standards for forensic science used in investigations and prosecutions.
They exist precisely to prevent fraudulent, bias, or scientifically unsound testimony from entering the courtroom and poisoning a jury's mind.
So you have this incredibly heavy professional burden. You have to stay objective, you have to know your role, and you have to avoid the temptation to advocate for the side paying you.
But to survive all of this, you actually have to understand the arena you are walking into. You can't play the game if you don't know the rules of the field.
That brings us to the two massive pillars of the legal system: criminal law and civil law.
The texts point out that while specific laws vary wildly from country to country, what is a routine legal medical practice in one jurisdiction might be a severe crime in another. These two broad divisions are pretty much universal across Western legal systems.
Let's tackle criminal law first. This is fundamentally the state versus the individual.
That is the core defining relationship.
Criminal law addresses offenses that are deemed to be so severe or so disruptive that they are considered acts against the public interest.
We are talking about murder, assault, grievous bodily harm, terrorism, severe fraud.
In these matters, the state steps in to act as the voice or the agent of the people.
So if someone is assaulted in the street, it isn't the victim who officially prosecutes the offender.
No, it is the state prosecuting the offender on behalf of society, because society as a whole is harmed when its laws are violently broken.
Right, which is why when you see court cases in the U.S. on TV, it's the people versus John Doe.
Exactly. Or in the UK, which the text uses as its primary structural example, the prosecution is handled by the Crown Prosecution Service, the CPS.
But the CPS doesn't just act like a conveyor belt, mindlessly prosecuting every single person the police happen to arrest.
Not at all. They have a very rigorous, specific two-part test they have to run through before they even set foot in a courtroom.
Yes, the CPS must clear two distinct hurdles. If they fail either one, the case generally does not proceed.
The first is the evidential test. The prosecutor must coldly and objectively look at the file and ask, is there enough reliable and credible evidence to provide a realistic prospect of conviction against the defendant?
And this is where the medical notes become life or death for a case.
Precisely.
If I'm the clinical forensic physician and my notes on a victim's injuries are illegible, vague, or lack photographs, the prosecutor looks at that and says, I can't put this doctor on the stand.
A good defense lawyer will tear those notes to shreds.
The evidence isn't reliable, the realistic prospect of conviction drops to zero, and a violent offender goes free. The case stops right there at hurdle number one.
Exactly. The evidence must be admissible in court, and it must be robust enough to withstand fierce cross-examination.
But let us say your notes are perfect. The photographs are pristine, the DNA is a match, the evidential test is passed with flying colors.
The CPS still has to clear the second hurdle, the public interest test.
This one is fascinating because it introduces a layer of societal pragmatism.
The prosecutor must ask, even though we can prove this person did it, is it actually in the public interest for the state to spend time and resources bringing this case to court?
Now, generally speaking, if a serious offense is committed, a prosecution will usually take place. But the prosecutor has to weigh the factors.
So if you have a 90-year-old woman with advanced dementia who shoplifts a carton of milk from a grocery store, the CCTV is perfect. She admits it. The evidential test is passed.
But prosecuting a confused elderly woman for a $2 item is clearly not in the public interest.
An out-of-court disposal or involving social services is the appropriate route.
Conversely, the more serious the offense, the more vulnerable the victim, or the worse the offender's historical record, the more strongly the scales tip toward prosecution being absolutely required in the public interest.
It is a constant balancing act performed by the state.
Okay, so that is the criminal arena. The state is involved, the police are involved, and the goal is often punishment or removing a danger from society.
Now, let's pivot entirely to the other pillar, civil law.
This isn't the state stepping in. This is individual versus individual.
The civil arena is concerned entirely with the resolution of disputes. It might be between two individuals, or between an individual and a corporation, or a family and a hospital trust.
Crucially, the aggrieved party, the claimant, initiates the legal action, not the state.
This encompasses a vast array of human friction, alleged clinical negligence, breach of contract, debt recovery, libel, and family law.
And for medical professionals, the civil courts are often where they spend the most time.
Absolutely. If you are a pediatrician, you might find yourself in a civil family court dealing with safeguarding children, or care proceedings where a local authority is trying to take a child into care.
Or if you are a surgeon, you might be in a civil court defending a clinical negligence claim.
And the remedies sought are fundamentally different. A criminal court has the power to take away your liberty, prison sentences, mandatory community service, punitive fines.
A civil court is generally not looking to punish in the same way, right? It is looking to restore.
The goal is usually to restore the claimant to the position they would have been in had the wrong not occurred.
This is most frequently achieved through financial compensation or by the court issuing protective injunctions, like a non-molestation order in a domestic violence case.
But the absolute most crucial difference between these two pillars, the concept that every single medical student listening needs to sear into their prefrontal cortex right now, is the standard of proof.
The bar you have to clear to win.
Yeah, let's unpack the criminal standard first, because it is deliberately the highest bar in our legal system.
It must be the highest bar because the state is threatening to take away a citizen's freedom or, in some jurisdictions, their life.
In a criminal trial, the burden of proof rests entirely and permanently on the prosecution. The individual sitting in the dock does not have to prove their innocence. They are presumed innocent.
The prosecution must prove their case to the jury or the magistrates beyond reasonable doubt.
In modern courtrooms, judges will often simplify this for a jury by telling them they must be sure that the defendant is guilty.
I want to spend some time on where this comes from, because the text anchors this standard to a profoundly important 1935 case, Wilmington versus Director of Public Prosecutions.
This isn't just legal trivia, it's the bedrock of how we view justice.
The Lord Chancellor at the time, Viscount Sankey, delivered a ruling that talked about a golden thread running through the web of English criminal law.
The Wilmington case is a masterclass in legal philosophy. To give you the context, Reginald Wilmington was a young man whose wife had left him.
He went to her mother's house with a sawn-off shotgun, claiming he intended to threaten to kill himself if she wouldn't come back.
The gun went off, his wife was killed, and Wilmington was charged with murder. At his original trial, the judge essentially told the jury that since Wilmington admitted the gun was in his hands and it killed his wife, the law presumed it was murder, and the burden was now on Wilmington to prove it was an accident.
Which sounds completely backward to our modern ears. The judge basically said, you are guilty until you can prove it was a mistake.
Exactly. Wilmington was convicted and sentenced to death. But he appealed all the way to the House of Lords.
And Viscount Sankey overturned the conviction, delivering one of the most famous speeches in legal history.
He stated that it is the absolute duty of the prosecution to prove the prisoner's guilt. If, at the end of the entire case, there is a reasonable doubt created by the evidence, whether that evidence was brought by the prosecution or the defense, the prosecution has failed, and the prisoner is entitled to an acquittal.
No attempt to whittle down that principle can be entertained. That was his exact phrasing.
The burden rests squarely on the state. It doesn't shift.
If I'm a forensic toxicologist testifying in a murder trial, and my lab results show lethal levels of a drug, but the defense points out a legitimate flaw in my chain of custody that creates a reasonable doubt the state loses.
That golden thread protects the individual from the terrifying power of the state. It is the ultimate safeguard.
Now, contrast that formidable barrier with the civil standard of proof. When an individual sues another individual, the stakes are financial or administrative, not a loss of liberty.
Therefore, the standard is significantly lower. It is based on the balance of probabilities.
Right. In civil proceedings, a fact will be established if the judge decides it is more likely than not to have happened.
If we have to put a crude mathematical percentage on it to understand it, it is 51%.
If a patient sues a surgeon for negligence, they don't have to prove beyond a reasonable doubt that the surgeon made a mistake. They just have to convince the judge that there is a 51% chance the doctor's negligence caused the specific injury.
If it's 51% likely, the claimant wins the compensation.
But this seemingly simple mathematical concept introduces a highly complex nuance that trips up seasoned practitioners all the time.
The text brings up a crucial 2006 Court of Appeal case, Re-In versus Mental Health Review Tribunal.
This case was fundamentally about clarifying a major misunderstanding regarding this 51% civil standard.
Yeah, this part of the chapter is a bit of a mind bender until you really look at it.
Historically, people thought that if a civil allegation was incredibly serious, let's say, a local authority in family court is accusing a parent of horrific, deliberate child abuse, and they want to remove the child permanently.
People assume the judge would say, well, the consequences here are so massive, I can't just use the 51% rule. The math has to change. I need to be 70 or 80% sure before I take this child away.
But the Court of Appeal in Re-In said absolutely not. There is only one civil standard.
The court ruled unequivocally that the standard of proof remains a single standard, the balance of probabilities, that 51% mark.
However, they declared that this single standard is flexible in its application.
What this means in practice is that the more inherently unlikely an allegation is, or the more serious the consequences if the allegation is proved, the stronger and more cogent the evidence must be before a court will find the allegation proved on that balance of probabilities.
I want to make sure I'm totally grasping this because it's vital for anyone writing a medical legal report. The percentage line doesn't move. The finish line is always 51%.
Correct.
But if I'm accusing someone of a minor breach of contract, a few lightweight documents might be enough weight to push the scale to 51%.
Exactly.
But if I'm accusing a parent of fracturing their baby's skull, the inherent unlikelihood of a parent doing that, plus the devastating consequences of removing the child, means the judge requires incredibly dense, high-quality, unshakable medical evidence to even reach that same 51% mark.
You have grasped it perfectly. The flexibility lies not in moving the goalposts of probability, but in demanding a much heavier, denser quality of evidence to achieve that probability.
It is a judicial safeguard.
It prevents courts from lightly accepting flimsy circumstantial evidence when the stakes for the families or individuals involved are life-altering. As a medical expert in the civil case, if your findings are supporting a severe allegation, your clinical reasoning and your data must be correspondingly robust.
To round out this section on the legal arenas, the text briefly contrasts the Anglo-Saxon legal model we've been deep diving into with the system used in continental Europe.
It is a really good reminder that law isn't a law of physics. It is heavily influenced by regional history and culture.
It is a critical distinction, especially for practitioners who might consult internationally.
The Anglo-Saxon system, which you find in England, Wales, the US, Australia, Canada, is an adversarial system.
It is essentially a structured combat.
The prosecution and the defense battle it out. They each present their own evidence, they fiercely attack the other side's evidence, and the judge sits somewhat passively, acting as an impartial referee, ensuring the rules of evidence are followed.
Whereas continental Europe generally uses an inquisitorial system, which has its roots in Napoleonic law.
Yes, in the inquisitorial system, the court itself, the judge, or a panel of judges, is actively involved in investigating the facts of the case.
The judge is the investigator.
They direct the police, they call the experts, they ask the primary questions. It is much more reliant on compiling a comprehensive written dossier of documentary evidence rather than relying on the theatrical, live, courtroom battles of cross-examination that define the adversarial system.
Let's ground all this theory with a quick look at the actual physical court structure the text provides. It helps to visualize the arena you might actually be summoned to.
In England and Wales, criminal cases generally start at the bottom in the magistrate's court.
These are usually heard by panels of lay magistrates, not professional judges, and they handle the vast majority of less serious crimes.
If a crime is severe murder, rape, armed robbery, he gets kicked up to the Crown Court. This is where you have a professional judge and a jury of 12 members of the public.
If there are disputes about the law, appeals go up to the Court of Appeal Criminal Division, and very rarely the highest court in the land, the Supreme Court of the United Kingdom.
And the civil structure mirrors that ascending hierarchy. Most routine civil disputes, debt claims, and localized family matters start in the county court or the family court.
If the issue is highly complex, involves massive sums of money, or novel points of law, it moves up to the High Court, which is geographically based in London but sits across the country.
The High Court is split into specialized divisions like Chancery, Family, and the Queen's Bench. Appeals from there go to the Court of Appeal, and again, ultimately to the Supreme Court.
The crucial takeaway for any practitioner receiving a summons is to immediately identify which court they are being called to.
The atmosphere, the procedural rigidity, and the expected format of your oral evidence will vary significantly between a local magistrate's court and the High Court in London.
Which brings us perfectly to the next massive conceptual block. Regardless of whether you are in a sweaty magistrate's court on a Tuesday afternoon or the wood-paneled High Court, if you are a doctor stepping into the witness box, the law violently forces you into one of two very distinct categories.
You're either a professional witness or an expert witness.
And confusing these two roles is pretty much the fastest way to humiliate yourself and tank a case.
It is, without a doubt, the single most common error made by inexperienced clinicians in court. The legal system does not view being a doctor as a single, homogeneous entity.
The distinction between professional and expert is absolute, and it dictates entirely what words are legally permitted to come out of your mouth.
Let us define them rigorously. A professional witness is a clinician who gives factual evidence based entirely on their direct, personal, clinical involvement with a patient.
You are essentially equivalent to a guy waiting for a bus who happens to see a car crash. The court wants to know what you saw with your own eyes.
Except instead of a bus stop, you were in an operating theater, and instead of a car crash, you were reporting medical facts. And you testify based strictly on your contemporaneous clinical notes.
To demonstrate how deeply ingrained this rule is, the text reaches all the way back to 1924, citing a pioneer named Dr. C. Graham Grant.
He was a busy police surgeon operating in the gritty environment of the East End of London. He wrote a manual called Practical Forensic Medicine.
Over a century ago, amidst the smog and the gas lamps, he defined this role exactly as the Supreme Court defines it today.
He stated that professional evidence is simply evidence as to facts which have come to a medical man's knowledge in the ordinary practice of his profession.
It is a brilliant, timeless definition. Let's walk through a scenario to cement this. Let's say I'm an emergency medicine physician working a chaotic Friday night shift. The police bring in a guy who is in a bar fight.
I examine him. I see a jagged 4-centimeter laceration above his left eyebrow. I clean it. I put in 6 sutures. I note that he smells of alcohol, and I discharge him.
2 years later, I get a witness summons. When I get in that box, I am a professional witness. I can confirm the laceration. I can read my notes about the sutures. I can report the factual smell of alcohol.
And this is the crucial boundary. You offer absolutely no comment or opinion on the mechanics of how that injury occurred beyond what is medically factual.
The prosecution barrister might ask, "Doctor, in your opinion, was this laceration caused by a broken beer glass or a fist wearing a sovereign ring?"
As a professional witness, you must refuse to answer. You did not see the fight. You are not a recognized expert in wound ballistics. You are strictly the reporter of your own observations.
If you guess or offer an uncredentialed opinion, opposing counsel will dismantle you, and the judge may strike your testimony.
Now let's look at the other side of the coin, the expert witness. This is a totally different ballgame, and it comes with an immense amount of power and responsibility.
An expert witness is legally permitted to express an opinion about medical or scientific matters to assist the court in understanding evidence that is beyond the experience of a normal layperson or a jury.
An expert witness may not have had any direct clinical involvement with the patient at all. In fact, they rarely do.
Their authority to speak does not come from treating the patient. It comes from their specialized education, intense training, acquired skills, or decades of experience.
The judge actually has to formally determine if they are acceptable as an expert before they speak.
They are the ones who get handed the whole file. They get my professional witness statements from the ER, they get the crime scene photos, they get the police reports, and the court essentially says, "We don't understand what this means. Tell us your reasoned opinion."
Let us use the brilliant broken leg analogy from the chapter and expand on it, because it perfectly illustrates the handoff between the two roles.
Imagine a 3-year-old child is brought into the emergency department by a parent. The child is crying, unable to bear weight on their right leg. The parent claims the child simply tripped over a rug while running in the living room.
Okay, so I'm the pediatric emergency physician on duty. I examine the child. I note the swelling. I order an x-ray. The radiologist confirms a severe displaced spiral fracture of the femur.
I fulfill my safeguarding duties, alert social services, and treat the leg. If this goes to a family court or a criminal trial, I am called as the professional witness.
I testify I saw the child at 8 p.m. I observed a swollen thigh. I ordered an x-ray which showed a spiral fracture. That is the absolute limit of my factual evidence.
Exactly, you provide the foundation of fact. Then, the court realizes they need to understand how that specific fracture occurred to determine if the parent is lying.
So, the court instructs a consultant pediatric orthopedic surgeon to act as an expert witness. This surgeon was not at the hospital that night. They have never met the child. But they spend hours analyzing the x-rays, reviewing your ER notes, and reading the parent's statement.
And when they get in the witness box, they get to opine on the mechanics.
They do. They might testify based on my 20 years of specializing in pediatric bone trauma and citing the relevant biomechanical literature. The immense rotational twisting force required to shear a toddler's femur in this specific spiral pattern is highly inconsistent with a low-velocity trip and fall on a living room rug.
It is, however, entirely consistent with a scenario where the limb is forcefully grabbed and violently twisted by a larger individual.
Boom. The professional witness provides the what, and the expert witness interprets the how and the why. The professional provides the raw data, the expert provides the meaning.
But of course, clinical medicine is messy, and the text openly acknowledges that in certain specialties, there's a massive overlap. Sometimes you have to wear both hats on the same day.
The classic, unavoidable example of this overlap is the forensic pathologist. They are inherently both.
When a pathologist performs an autopsy, they are conducting professional fact-finding work. They are physically measuring the length of a stab wound. They are weighing the heart in grams. They are photographing the trajectory of a bullet.
Those are indisputable facts recorded contemporaneously.
But then, at the end of that same autopsy report, they transition seamlessly into the expert role.
They synthesize all those raw weights and measurements and offer a concluding expert opinion on the medical cause of death. They say, based on these facts, it is my expert opinion that the cause of death was exsanguination due to a severed femoral artery.
Clinical forensic physicians do this as well. They examine a victim of domestic assault, documenting the specific color and size of bruises facts.
Then they might be asked to provide an expert opinion on the likely age of those bruises, or whether the pattern matches a specific weapon.
The vital survival skill for the practitioner is internal awareness. You must know exactly when you are shifting from fact reporting to opinion giving, and you must make that shift explicitly transparent to the court in your reports and your testimony.
Because expert opinions carry such immense, terrifying weight, they can literally sway a jury to convict a person of murder or exonerate them entirely. The courts have developed incredibly strict, unforgiving rules to govern who gets to be an expert and what they are allowed to base their opinions on.
This takes us into the meat of Section 4. The burden of expertise. The text dives deeply into the legal tests for the admissibility of expert evidence.
And it starts by looking at the United States, because the U.S. legal system underwent a massive philosophical evolution on this issue.
It is a fascinating piece of legal history. For decades, the U.S. courts relied on something called the Fry test, which originated from a 1923 case involving an early rudimentary lie detector machine.
The Fry test essentially established a standard of general acceptance. It asked, is this scientific principle or technique generally accepted as reliable within its particular scientific community? If the community consensus was yes, the expert could testify.
But the problem with relying solely on consensus is that science moves significantly faster than consensus. And sometimes the established consensus is just flat out wrong.
If you only allow generally accepted science, you block cutting-edge, valid novel research from the courtroom.
And conversely, sometimes a whole field accepts a technique like certain types of bite mark analysis that later turns out to be scientifically hollow.
Exactly. The Fry test became inadequate for dealing with complex modern science. So in 1993, the United States Supreme Court made a monumental tectonic shift in a case called Daubert versus Merrill Dow Pharmaceuticals.
This is a legendary case. It was a civil lawsuit involving a morning sickness drug called Bendectin. The plaintiffs claimed the drug caused horrific birth defects.
Merrill Dow, the pharmaceutical company, had loads of published, generally accepted studies saying it was safe. The plaintiffs had experts who reanalyzed the data using novel statistical methods to say it was dangerous.
Under the old Fry test, the plaintiffs' novel methods weren't generally accepted yet, so their experts were blocked. The Supreme Court had to decide how to handle this.
And in doing so, the Supreme Court shifted the entire standard from general acceptance to scientific reliability. They essentially deputized the trial judge to act as a strict gatekeeper of the science.
Under the Daubert standard, which eventually became codified in the Federal Rule of Evidence 702, judges can't just count hands to see if a theory is popular. They must actively interrogate the methodology.
The judge has to ask a checklist of hard questions. Is the expert's proposition actually testable? Has it been empirically tested? Has the methodology been subjected to rigorous peer review and publication?
What is the known or potential error rate of the technique? Are there operational standards governing how the technique is performed?
It forced experts to prove the underlying objective scientific rigor of their opinions, rather than just cruising on their professional reputation or the popularity of a specific theory within their clique. It demanded that courtroom science look like actual laboratory science.
Now, across the Atlantic in the UK, the courts were dealing with their own issues of experts behaving badly. The rules governing the specific duties of an expert were famously codified by a brilliant judge named His Honor Judge Creswell.
This happened in a 1993 civil case involving a ship, and it is universally known in legal and forensic circles as the Carrion Reefer case.
If you do any expert work in England or Wales, the principles laid out here are your absolute bedrock. We need to go through these meticulously because they are essentially the 10 commandments for expert witnesses.
They truly are the commandments, and they were born out of judicial frustration. The Carrion Reefer was a ship that caught fire and sank off the coast of Sierra Leone.
The ship owners claimed it was an accidental fire and demanded their insurance money. The insurance company claimed the owners deliberately set the fire to cash in on the policy.
Both sides brought in a small army of highly paid fire investigation experts. During the trial, Judge Creswell realized that these experts weren't acting like independent scientists. They were acting like aggressive cheerleaders for the side paying their massive fees.
They were ignoring evidence, hiding facts, and arguing like lawyers.
So Judge Creswell had enough, and in his judgment, he laid out a numbered list of duties that every expert must follow. Commandment 1, the absolute paramount duty, independence.
Expert evidence should be, and should clearly be seen to be, the independent product of the expert. It must be completely uninfluenced by the exigencies of litigation.
You are not there to win the case for the person paying your invoice. You are there to assist the court.
Commandment 2 flows from that. Provide objective, unbiased opinion in relation to matters within your expertise.
Commandment 3 is perhaps the most frequently violated by enthusiastic doctors. An expert witness should never assume the role of an advocate.
This is a huge psychological shift for doctors. If you are a doctor in a clinic, you are an advocate for your patient. You fight for their care, you fight the insurance companies, you advocate for their health.
But the second you step into the courtroom as an expert, that advocacy must die. You are an advocate for the truth, and your duty is entirely 100% to the court itself.
You must state the facts or the assumptions upon which your opinion is based. And crucially, You must absolutely never omit material facts that could detract from your conclusion.
This is the antithesis of legal strategy. A lawyer will naturally try to hide their weak points. An expert is legally mandated to shine a spotlight on their own weak points.
If you write a brilliant 20-page report explaining why a suspect's physiology proves they committed the crime, but you find one obscure blood test result that slightly weakens your entire theory, you are legally bound to include that test result and explain why it weakens your theory.
The humility aspect is codified here too. You have to make it explicitly clear when an issue falls outside your area of expertise. You can't just guess because you have a medical degree.
And if you think you don't have enough data to form a solid opinion, maybe the medical records are incomplete, you have to state plainly that your opinion is merely provisional.
And perhaps one of the most critical, ongoing duties that catches people out is the duty to update. Let us say you write a comprehensive report for the defense team. 6 months go by.
Just before trial, the defense lawyers send you the prosecution expert's newly filed report. You read it, and they point out a complex physiological cascade mechanism you genuinely hadn't considered. You realize with a sinking feeling that your initial opinion was wrong.
You can't just quietly shred your report and hope nobody brings it up.
No, you have a strict, immediate legal duty to communicate that change of view to all parties through the legal representatives. You must formally amend your position.
You cannot hide it, and you cannot let the court rely on an opinion you no longer hold.
To really hammer home what happens when experts fail these duties, especially regarding highly specialized controversial science, the text brings up a very sobering 2016 High Court case Squire versus GMC.
This involved a regulatory panel's findings regarding an expert in a highly contentious medical arena shaken baby syndrome, or more accurately, non-accidental head injury.
The Squire case is a monumental landmark for how experts must handle controversial hypotheses. Dr. Wayne Squire was a highly respected pediatric neuropathologist.
For years, she testified for the prosecution, supporting the main medical triad, subdural hematoma, retinal hemorrhage, and encephalopathy as definitive proof of shaken baby syndrome.
But over time, she reviewed new biomechanical literature and her views completely shifted. She began testifying exclusively for the defense, arguing that this triad could be caused by natural causes or minor accidents, not just violent shaking.
Which is fine. Science evolves. But the issue wasn't that she changed her mind. The issue was how she presented her new minority viewpoint to the courts. The General Medical Council investigated her, and the High Court ultimately ruled on her conduct as an expert.
The courts established that when you are advancing a theory that is a minority view, or not universally accepted by the mainstream medical establishment, your duties under the Icarian reefer become even more stringent.
You cannot simply present your controversial hypothesis to a jury of laypeople as if it is established, undisputed clinical fact. You have an absolute duty to explicitly explain to the court that your hypothesis is controversial.
You essentially have to make the other side's argument for them. You have a duty to actively provide the court with all the mainstream, peer-reviewed material that directly contradicts your own controversial hypothesis.
You have to say, here is my theory, but you must know that 90% of my colleagues think I'm wrong, and here are their papers explaining why.
You cannot just present one side of an ongoing, heated scientific debate. You must set out all the literature you relied upon, both for and against.
The text follows that up with a quote from another vital case, Kennedy versus Cordia, which sums up the judicial attitude perfectly. It adopts a principle that an expert's bare, bold statement of opinion, no matter how eminent the expert, is of no real assistance to a court.
The judge explicitly stated the expert cannot just state his opinion, the expert has to justify it.
You have to show your work, like a high school math test. You have to reveal the entire intellectual process of reasoning that led you from the raw data to your final conclusion.
If I say the bruising is indicative of abuse, the judge will say why. Explain the degradation of hemoglobin. Explain the mechanical force required. Explain the literature.
If you cannot clearly and logically articulate the why and the how behind your opinion is inadmissible. The court needs the tools to evaluate your reasoning, not just bow to your institutional authority.
Okay, so let's say you've mastered all of this. You know the law, you know whether you are a professional or expert witness, and you've written a brilliant, objective, heavily cited report that complies with every single Icarian reefer rule.
Now comes the visceral, physical reality of the job. Section 5, surviving the stand. You actually have to go to court and testify.
And the text gives some incredibly practical, almost gritty advice about the mechanics of this experience. First, let's clear up the initial paperwork that gets you there. What is the difference between a statement and an affidavit? Because you don't want to sign the wrong one.
This depends entirely on the legal arena you are operating in. In a criminal case, you will be asked to provide a statement. This document has very specific, standard legal wording at the top, governed in England by the Criminal Justice Act.
It is a formal declaration where you confirm you are telling the truth, and crucially, you acknowledge that you are liable for criminal prosecution for perjury if you willfully state in it anything which you know to be false or do not believe to be true. It carries a blatant perjury warning.
It's the legal equivalent of a hazard sign. It focuses the mind of a junior doctor very quickly. In civil proceedings, however, you typically provide an affidavit.
Yes, an affidavit is a sworn statement. This means you literally make an oath or a formal legal declaration before a solicitor, a notary public, or an official of the court at the exact time of signing it.
It carries immense civil weight, and lying on an affidavit can lead to charges of contempt of court or perjury.
Now, in many continental European inquisitorial systems, handing in that perfect written statement might be the end of your involvement. The judge reads it, and that's it.
But the Anglo-Saxon adversarial system loves a live performance. They want to test the evidence in the crucible of the courtroom. They want to see your face when you answer the hard questions, so you get called to court.
The text notes that courts have witness liaison units that will try to negotiate a convenient date, but ultimately the court has the sheer power to compel you to attend using a formal witness summons.
If you ignore a summons because you have a busy clinic, you are in contempt of court and could literally face a fine or a prison sentence. So you clear your schedule, you travel to the court, and you wait.
And you must mentally prepare for the waiting. It is infamous and psychologically draining. You will likely find yourself sitting in a bleak court cafeteria drinking terrible coffee for hours on end.
Cases frequently plead out at the last possible second, meaning you are sent home without testifying. Or fierce arguments over the legal admissibility of a piece of evidence happen while the jury is sent out of the room, stalling the whole process.
The text practically advises you to bring work or a book with you, but eventually the usher calls your name and you walk into the courtroom.
You walk in, you see the judge, the barristers in their wigs if you're in the UK, the jury box. It's an intimidating architecture designed to impress upon you the gravity of the state. The very first thing that happens is the swearing-in process. You must publicly commit to telling the truth.
You are given a choice. You can take a religious oath, swearing on a holy book relevant to your personal faith, a Bible, a Quran, a Torah, a Gita. Or if you are non-religious, or simply prefer it, you can make a secular public affirmation.
It is absolutely vital to know that both have the exact same absolute legal weight. Once you say those words, regardless of the format, you are bound by the severe penalties of perjury.
Then the actual testimony begins. And it is highly structured. It happens in 3 distinct sequential phases. Phase 1 is the examination in chief.
The examination in chief is conducted by the lawyer who called you to the stand, whether that is the Crown prosecutor or the defense barrister. This is usually the gentlest, most structured part of the experience.
Their goal is to establish your credentials, formally bring your written report into the court's evidence, and ask you to verbally confirm the key facts or opinions you have already written down. They want you to explain your findings clearly and simply so the judge or jury can understand your baseline position.
It feels like a friendly interview. But then phase 2 begins. The cross-examination. The barrister who called you sits down, and the barrister for the opposing side stands up.
And their entire professional job, their duty to their client, is to aggressively test your evidence, find the microscopic weaknesses in your reasoning, and frankly see if they can rattle you.
This is where courtroom dynamics shift from medical reporting into highly specialized psychological warfare. The opposing counsel's role is to identify inconsistencies, highlight inaccuracies, or expose vulnerabilities in your scientific reasoning.
And as the text explicitly warns, witnesses must expect to have their qualifications questioned, their clinical experience minimized, and their fiercely held opinions vigorously, sometimes mockingly, challenged. Counsel will probe relentlessly for any hint of bias.
And the text specifically warns about the emotional trap here. It notes that becoming hostile, angry, flippant, or rude as a witness is a vulnerability that counsel will happily exploit.
Absolutely. You must remember that the lawyers are in their home arena. They play this game every single day. They are in complete control of the pacing, the phrasing, and the special dynamics of the courtroom.
A common strategy might be to intentionally ask repetitive, seemingly ignorant or borderline insulting questions to try and elicit an angry, arrogant, or defensive response from you.
Why do they want you angry? Because an angry expert looks biased. An angry expert looks emotionally invested in winning the argument, rather than objectively assisting the court.
If a jury sees a doctor lose their temper and start shouting at a lawyer, that doctor instantly becomes less credible. If you lose your temper, you lose your objectivity, and you have failed in your duty.
You must remain dispassionate, agonizingly clear, and unfailingly professional no matter how provocative the questioning gets.
There is also a very specific tactical trap the text mentions that lawyers use frequently with medical experts, the yes-no trap. A barrister will outline an incredibly complex medical scenario, perhaps involving multi-organ failure, pre-existing comorbidities, and competing physiological cascades, and then aggressively lean forward and say, answer the question with a simple yes or no, doctor. Did the defendant's punch cause the death?
It's an impossible question. If you say yes, you ignore the comorbidities. If you say no, you ignore the blunt force trauma. You are cornered. What is the correct legal response?
You must recognize the trap instantly and confidently decline to step into it. A simple yes or no is often entirely insufficient for complex medical realities. It is a deliberate attempt to unfairly circumscribe your answer to fit the lawyer's narrative.
The text advises that you should politely decline the restriction, physically turn your body away from the aggressive lawyer and toward the judge, and explain to the judge that it is simply not possible to answer such a complex medical question accurately with a single word.
The judge is seeking the truth and will almost always intervene and allow you to expand your answer fully.
Phase 3 is re-examination. The opposing counsel sits down, and the lawyer who originally called you gets to stand back up and ask a few more questions.
They can't introduce completely new topics, but they can try to clarify anything messy or confusing that came up during the cross-examination.
But honestly, the absolute best summary of how to survive the entire ordeal on the stand is the old rhyming adage the text quotes. It is timeless advice for any witness. Dress up, stand up, speak up, and shut up.
It is brilliantly concise advice. Dress up means wearing conservative, smart business attire, a dark suit, a professional dress. It shows inherent respect for the formality of the court and visually underscores your professional authority before you even speak.
Stand up refers to the traditional posture in the witness box. Though many modern courts now allow sitting, however, standing often helps project confidence and voice.
Speak up is vital. The microphones you see in court are almost always just for the recording system, not for amplifying your voice to the room. You must project. You must speak clearly, slowly, and loudly enough for the jury and the judge to hear every syllable.
And you must keep in mind that the judge is handwriting or typing notes. You will often be asked to pause mid-sentence so the judge's pen can catch up. Watch the judge's pen.
And then there's the final and most frequently violated rule, shut up.
Yes, shut up. When a barrister asks you a question, you answer that specific question. You answer it completely, you answer it concisely, and then you literally stop talking. Close your mouth.
Do not try to fill the awkward silence. Silence is a potent psychological tool that lawyers use to make witnesses feel uncomfortable. Humans naturally want to fill dead air.
The lawyer will just stare at you, waiting for you to keep rambling, inevitably prompting you to say something you shouldn't, or volunteer unasked for information that accidentally opens up a massive new line of attack. When you have answered the question, stop. Wait calmly for the next one.
That is fantastic advice. But here is the brutal reality. Good oral evidence, no matter how well dressed you are or how well you handle the silence, is fundamentally impossible without flawless written documentation backing it up.
Which brings us to our final major section, Section 6, the paper trail. Everything you say on the stand is anchored to what you wrote down months or even years earlier in the middle of the night. And the text starts with a stark, terrifying warning about contemporaneous notes.
Contemporaneous notes, the medical notes you take at the exact time of your clinical examination or immediately following it, are the absolute, unshakable bedrock of your evidence.
The legal system operates on a harsh maxim: if it is not documented in the contemporaneous notes, in the eyes of the court, it simply did not happen.
You cannot sit in the witness box 3 years later and say, oh, I also remember the patient had a strange rash. If it's not in the chart, the court will not believe you.
The text strongly advises against using handwritten statements for court reports because they are open to dangerous misinterpretation. Type everything.
And there is a very practical, almost embarrassing warning here for clinicians. If you are relying on your original handwritten clinical notes to refresh your memory, make absolutely sure you review them and can actually read your own handwriting before you enter the witness box.
It sounds trivial, but it is devastating in practice. It is incredibly embarrassing and fatally damaging to your professional credibility to stand before a high court judge and a jury, be handed your own clinical chart, and be completely unable to decipher your own scrawl.
Opposing counsel will mock you, implying that if you cannot even read your own notes, how can the court trust your medical judgment?
The chapter also dives heavily into the ethics and legality of the paper trail, starting with the complex web of confidentiality and consent. We all know fundamentally that medical records are confidential. They belong to the patient.
Generally, releasing them to police or lawyers requires the explicit written consent of the patient. If you are asked by the police to write a medico-legal report about an assault victim and the victim refuses consent, you are paralyzed. You have to state that refusal explicitly.
But there are times when the law ruthlessly bypasses patient consent for the greater public good.
Yes, the text highlights mandatory reporting duties as prime examples of this bypass. These laws vary wildly by jurisdiction, but they are crucial exceptions to medical confidentiality.
For instance, the text cites the legal framework in Australia, where parliaments in all states and territories require the mandatory reporting of suspected cases of child abuse and neglect to government authorities by health professionals, though the specific clinical thresholds for reporting differ slightly from state to state.
And the UK example the text uses is very specific and relatively recent. Since 2015, regulated health and social care professionals in England and Wales have a mandatory legal duty to report any known cases of female genital mutilation, or FGM, in patients under the age of 18 directly to the police.
It is not a suggestion. You do not ask the patient or the parents for consent. The law mandates you pick up the phone and report it, breaching confidentiality to protect the vulnerable child.
Autopsy reports exist in another totally unique category of consent. An autopsy report is a highly specialized document. It is not commissioned by the deceased patient. It is commissioned by a legal authority, like a coroner, a medical examiner, or the police, depending on the jurisdiction.
Because the patient is deceased, the legal authority granted by the coroner to perform the autopsy entirely replaces the standard medical requirement for consent from a living patient or their family.
Which means the flow of information is tightly restricted.
Exactly. These reports are highly confidential, but they belong to the coroner. They are disclosed only to the commissioning legal authority.
The pathologist should absolutely not be handing out copies of the autopsy report to interested parties, grieving family members, or journalists. Disseminating that report is entirely the coroner's job and prerogative.
And finally, before we wrap up, the text addresses a deeply uncomfortable, ethically fraught reality about the paper trail: resisting alteration.
Imagine you write a brilliant, objective expert report. You submit it to the instructing lawyers who hired you. 2 days later, the lead lawyer calls you and says, "Doctor, this is a great report, but this one paragraph on page 4 about the victim's pre-existing heart condition is really detrimental to our civil claim. It muddies the waters. Can you just delete it? Or maybe rewrite the conclusion slightly to be more definitive."
This happens far more often than people realize, and the text is absolutely unequivocal about the required response. Doctors must steadfastly, firmly resist any pressure from lawyers or even police personnel to change, delete, omit, or alter parts of a report to suit a specific legal narrative.
If you hit delete on that paragraph, you become a hired gun.
The moment you yield to that pressure, you have completely abandoned your clinical objectivity, you have violated the Acarian-Refer principles, and you have fundamentally breached your duty to the court.
You must remember your duty is never to the instructing body. Your duty is never to the law firm paying your exorbitant invoice. Your primary overriding non-negotiable duty is to assist the court in finding the truth.
If the pressure from the lawyers becomes persistent, aggressive, or inappropriate, you may need to formally withdraw from the case, refer the matter to your professional regulatory body, or seek the direct guidance of the judge.
It all comes roaring back to that core philosophy: independence. You are a small piece of the jigsaw, but your piece must be perfectly accurately cut, regardless of who is trying to force it into the wrong spot.
Okay, we have covered a massive amount of conceptual ground today, from the high-minded philosophy of preventing anarchy down to the gritty psychological reality of cross-examination and terrible cafeteria coffee. It is time to see what has stuck in the memory.
We are going to do our learning reinforcement segment. If you are preparing for exams, this is how they're going to test you on Chapter 1.
I am going to throw out 6 rapid, single best answer style prompts. I will read the scenario, our expert will pause to let you, the listener, lock in your answer, and then we will give the solution and tell you exactly where in the chapter you can find the underlying concept. Ready? Let's go.
Sounds good. Hit me with the first one.
Question 1. What landmark 1935 case established the golden thread principle, legally mandating that the burden of proof in a criminal trial lies entirely and permanently with the prosecution to prove guilt beyond a reasonable doubt?
We will give you a second to think about that golden thread.
All right. What is the official answer?
The answer is Wilmington versus Director of Public Prosecutions. If you miss the historical context of this, you need to review the criminal law section of the chapter.
Question 2. In civil law, how does the balance of probabilities standard legally adapt to highly serious allegations, such as severe child abuse, according to the pivotal ruling in Re-N versus Mental Health Review Tribunal?
Think about what changes and what stays the same when the stakes get higher.
Have you locked it in?
The answer is that the mathematical standard remains a single standard. It is always 51%, but the quality, strength, and cogency of the evidence required increases significantly to meet that standard. You can review this crucial nuance in the civil law section.
Question 3. A doctor is called to court. They provide factual evidence about suturing a laceration, reading directly from their contemporaneous clinical notes, and they explicitly refuse to offer an opinion on how the injury actually occurred. What specific legal role are they fulfilling?
Think back to the broken leg analogy.
Got your answer.
They are acting strictly in the role of a professional witness. This vital boundary distinction is found in the doctors and the law section.
Question 4. Which specific set of legal principles derived from a famous 1993 maritime case dictates that an expert witness must be fiercely independent, objective, and must never assume the role of an advocate for the instructing party?
Remember the 10 Commandments we discussed.
Okay. What is the name of that case?
Those are the duties derived from the Icarian reefer case. The detailed, point-by-point breakdown of these absolute duties is in the expert witness section.
Question 5. You're sitting in the witness box under aggressive cross-examination. An opposing counsel demands you answer a highly complex physiological cascade question with a simple yes or no. What is the correct medico-legal response?
Think about how you handle that trap.
All right, what should you do?
The correct response is to politely but confidently decline the restriction, turn to the judge, and explain why the complex question cannot be accurately or truthfully answered with a simple yes or no. The strategy for handling this is covered in the healthcare professionals as witnesses in court section.
Question 6, our final question. In the specific context of forensic autopsy examinations, what legal construct replaces the standard medical requirement for obtaining patient consent?
Remember who actually commissions the autopsy.
What is the construct?
The legal authority to perform the autopsy, which is formally granted by the coroner or relevant judicial body, entirely replaces the need for consent. This is detailed in the preparation of medical legal reports section.
Brilliant. If you locked in all 6 of those, you have a rock-solid grasp of the foundations. Before we sign off, I want to leave you with a final provocative thought to mull over. We've talked extensively today about rules established in the 1990s with cases like Daubert and Icarian Reefer, and even rules from the 1920s with Fry and Dr. Grant.
But think about the sheer terrifying velocity of scientific advancement happening right now.
We are rapidly entering an era of algorithmic diagnostics, genomic phenotyping from microscopic crime scene DNA, and AI-assisted digital pathology. How will the rigid legal frameworks we discussed today, like the Daubert test, which demands you explain the exact methodology and error rate, adapt when the expert analyzing the data is essentially relying on an AI black box that even the programmers don't fully understand?
It is a profound challenge for the justice system. The science will evolve at breakneck speed, but the core duties, the duty to the court, the commitment to transparency, and the absolute necessity of independence must remain the permanent anchors of forensic practice, regardless of the technology used.
Rapid scientific advancements are continually going to push the boundaries of legal admissibility. The challenge for tomorrow's practitioners isn't just knowing the law, it is maintaining that unshakable, foundational objectivity in an era of unprecedented, overwhelmingly complex data. Keep your textbooks open, stay fiercely objective in every single clinical note you write, and we look forward to having you join us for the next deep dive.